Good afternoon, dear friends, colleagues, guests, students. We are very, very happy to open this workshop of the Italian Yearbook of International Law, the workshop on the 31st volume of the Yearbook, and a very good opportunity to discuss topical issues of international law. When teaching international law, I am struggling to explain to my students what the UN is, what is the meaning of the United Nations today, and I was really privileged to be able to organize this workshop to discuss the topic on the eve of the organization's 80th anniversary. The idea of the title comes from this struggle to understand, first of all, as scholars, and then to try to explain to students and to people who do not deal with international law daily what is happening and what is the meaning of the organization today. So this is the reason why, together with the co-organizers of the workshop, we settled on the United Nations on the eve of its 80th anniversary, Contestation, Resilience, and Change. Thank you for being here. I hope we will have 2 days of very fruitful discussion. And I give the floor, I welcome you all, not only as an international law professor here, but also as head of the Department of Law. But this conference is organized also in the framework of our activities within the PhD school of the department, which deals with European Union law and national legal systems. So it's my privilege to give the floor to Professor Giovanni De Cristofaro, who is a civil lawyer, but has accepted to delve into international law just to open our discussions today. Giovanni, you have the floor.
Thank you very much. Distinguished guests, dear colleagues, dear students, I am deeply pleased and honored to have the opportunity to extend to all of you my warmest welcome in my role as coordinator of a PhD program in European Union law and national legal systems of the University of Ferrara. The topics addressed by this workshop have a very strong connection, of course, with the research items of our PhD program and are therefore of great interest for the professors and researchers who are involved in such a program, as well as for our PhD students. I would like firstly to thank the distinguished speakers and guests who kindly accepted the invitation to take part in the conference and honor us with their presence. I hope you will have a possibility to enjoy the hospitality of our law department and appreciate the beauty of our wonderful city of Ferrara. Secondly, I would like to thank the members of the scientific committee, and first of all, of course, our Dean, Serena Forlati, who drew up the program for this workshop, choosing to devote it to a topic of great relevance and complexity from a legal and political point of view. It is increasingly clear to all of us that our future will depend to a large extent on the answers that the United Nations and the national governments will be able to give to the issues that the speakers will address in their papers and in their intervention today and tomorrow. A special thanks to the Board of Editors and the editorial committee of the Italian Yearbook of International Law, a scientific journal that enjoys great national and international prestige, who have chosen our law department in Ferrara as a venue for the presentation and discussion of a 34th volume of the Yearbook, just published and precisely devoted to the role and resilience of the United Nations on the eve of its 80th anniversary. And finally, last but not least, I would like to extend my sincere thanks to Cristina Gavric and Marilu Porchia of the University of Ferrara, members of the organizing committee who excellently supported the scientific committee by taking care of the organizational aspects of the conference. The importance of the topics covered and the authority of the speakers will ensure the value and the relevance of the contents and the outcomes of the discussions that will take place in this workshop today and tomorrow. And I am very sincerely and deeply proud to associate our PhD program with such a high-profile conference. Thank you to all of you again, and welcome in Ferrara. I wish you all a good work for today and tomorrow.
Thank you very much, Giovanni, for your support. And I now give the floor to Professor Riccardo Pavoni, University of Siena. You know him very well. He is the editor-in-chief of the yearbook. Riccardo, you have the floor.
Thank you, Serena, and so welcome everybody again. I just will speak for a couple of minutes because then we are very much looking forward to hearing our speakers. I just need to thank very much the University of Ferrara, Professor De Cristofaro, my colleague Serena, for the hospitality and for this unwavering support to this initiative. This is very important for the success of our publication. So thank you for hosting us in this beautiful city of Ferrara and in this very ancient and prestigious University of Ferrara. We also need to thank 3 Italian publishers here. We need to thank Edizioni Scientifiche Italiane, we need to thank Giappichelli Editore, and we need to thank Editoriale Scientifica. Actually, the first 2, Edizioni Scientifiche Italiane and Giappichelli, have their own desk here, whereas Editoriale Scientifica was not able to organize a desk, so they are not present, but they gave us some financial support for our publication. So we are very, very thankful to them. I'm also very thankful to my colleagues in the scientific committee organizing this conference. I'm talking about Giuseppe Nesi, who is here with us. Actually, the original idea to devote this workshop to these themes was one of Giuseppe Nesi's idea last year, and then I collaborated especially with him, with Serena, and of course with Daniela Moroso, who is also here throughout the whole year to organize this event and to decide and speakers. So I'm very thankful to them. But of course, I mean, the success of an initiative such as this one is not forthcoming when it's not really a really common endeavor. And this is really a common endeavor because all the members of the board of editors and of the editorial committee of the Italian yearbook have given their own contribution. So I'm also very thankful to them. Just one word to clarify the purpose of the workshop. Actually, this is our aim is to give the authors of the next volume a chance to introduce their topic, to present their own preliminary ideas on the specific theme that they are talking about, that they are dealing with, and hopefully to receive feedback from the floor, from us, from the colleagues. So I hope we will have some time also for questions and answers at the end of the presentations. I don't want to say much about the theme. The name of the work, of course, we took the chance of the 80th birthday of the United Nations, which will be next year. So the first title is The United Nations at 80, the 80th anniversary of the United Nations. And then we decided to add 3 adjectives here, to 3 actually words: contestation, resilience, and change. Of course, this was a deliberate choice, but we thought that these 3 words were, faithful in describing the current debates surrounding the United Nations as it approaches its 80th birthday. I don't want to say nothing about the meaning of contestation here. We are giving a lot of liberty to the authors here to decide what they mean by contestation when it comes to the UN. But I think that we also have our own ideas here, and so I don't want to say much about that. Also, we thought that resilience was describing very well the current state of affairs when it comes to the UN, because everybody knows that the United Nations is widely seen as an organization which is capable of adapting to the changing times, which is capable of showing resilience, as we say. And of course, change is self-explanatory. Everybody is speaking about much needed reforms, change, innovations in the UN system. So we thought that these three words were appropriate to just to give a thread to the authors to develop their own speeches and papers. So thank you very much, and I guess it's time to open the floor for the speakers.
Indeed. Thank you very much, Riccardo. I would just like to mention expressly that we are being recorded, actually in streaming, so just that you are aware about this. And I would kindly invite the speakers to take the floor. Before they do so, I would also like to thank the members of the scientific committee, but especially Christina Gavrish and Marilu Porchia, who really have earned their clap because of their excellent work in organizing everything. Thank you very much. And now, please, I would ask Chiara Redaelli, Christian Tams, and Alessandra Arnoni to take the floor. Grazie, Giovanni. So we did not give a title to this first session, but I think the thread between the three interventions that we will listen this afternoon has to do with the core functions of the UN, really, and how they have evolved and adapted over time. It's a real privilege to be able to hear from our three speakers, and I will not take time to speak my own mind about these topics, but I would just like to give the floor to the first of them, Dr. Chiara Redaelli. Santiago Villalpando is not here. He will contribute to the written version of the yearbook, but he could not actually make it to Ferrara today. So we are left with three presentations. The first one by Dr. Chiara Redaelli, as I was mentioning, on the UN and the reinvention of peace, which peace and for whom. I think this is really a topical issue today. We are witnessing an apparent irrelevance of the United Nations in too many contexts. But before giving a harsh assessment about the UN's role, maybe you should ask the question that you are raising, rightly so, in the title of your presentation. If the main role of the UN is to preserve international peace, what do we understand by this concept? Chiara Redaelli is working currently at the University of Geneva with a big research project precisely on this topic. She's also still for a little time a senior legal advisor at Diaconia IHL Center, and she's an expert on human rights and international humanitarian law. So Chiara, you have the floor, 20-25 minutes, I think, so that we can leave space for discussion.
Thank you. Can you hear me? So first of all, I would like to thank the organizers for taking care of everything. I'm very excited to be here. I admit that this is my first conference in Italy, so I'm very, very excited. So thank you for the invitation. It's very nice to be back after a bit more than 10 years. Now, I don't want to lose too much time, but again, really thank you to the organizers and also for managing, the strike and everything else. So now, I we'll start immediately. And just as a disclaimer, as Serena mentioned, this is part of a project that I just started at the University of Geneva, a project funded by the Swiss National Fund, and it will last for 4 years. So hopefully I will have time to develop these ideas further, but I would like to thank you for giving me the opportunity to discuss my preliminary ideas today with you. And so my starting point and the idea behind my project and also this article is the idea that indeed we often talk about jus ad bellum, jus in bello, international criminal law, transitional justice, and the ultimate aim of these branches of international law in general, and specifically of the United Nations, is peace. However, if you look at the definition of what is meant by peace in international law, you will not find an actual definition. So if we wonder, okay, this is the ultimate aim of the United Nations, but what is peace? And if we don't know what is peace, how can we make choices under international law, but more in general also in the international community on how to promote peace if we don't have a definition? And so the starting point is actually looking for a definition of peace, which doesn't come from international law, but actually come from sociology. And maybe you know Galtung, who was a sociologist, quite well known, maybe not so much among lawyers. And he developed the idea that there are two competing notions of peace. One is negative peace, which means absence of war, and the other one is positive peace, which is the idea of, okay, absence of war is very nice and good, but that's not enough. We also need the promotion of human rights, of justice, and this is what positive peace means. And it's basically to create the foundations to prevent wars. So it's not just absence of war, because if you think about it, like if you have a dictatorship, sure, you have peace, but how do people live within this framework? So this is my starting point, and again, the reason is that there is no definition in international law, so I had to look for a definition of peace outside international law. And then my next step was, okay, so we have these two notions of peace that come from sociology, but we could potentially use them within the international law framework. And my idea and my hypothesis, which I will further develop in the article, is that the notion of negative and positive peace coexist within the UN Charter and also more in general in the international legal framework. And so if you think about it, when the UN Charter was written, it was 1945. So obviously, but at the time, the idea of peace was mainly negative peace. So the idea is that, okay, we want to create the UN because we just had the Second World War, and we want to create a world where there is going to be peace. But in that case, peace was mainly absence of war. So you have some reference about human rights, for instance, in the UN Charter, but if you think about it, the main and most important articles when we talk about peace and IHL or use of force are actually about the use of force between states. So the UN Charter was really written to prevent international wars. So an idea of negative peace, meaning absence of war between states. And then with the so-called humanization of international law, the emergence of human rights from the 1960s, and already from the end of the Second World War, you have the emergence of human rights law. And this is when you start seeing in several sources of international law, but also UN Security Council resolutions, General Assembly resolutions, an idea of peace which is more positive peace. So it's not enough to have an absence of war. We also want to promote human rights, justice, equality. So this is the starting point, this tension between negative and positive peace, which exists, or at least this is my hypothesis, within the current legal framework. And the second part of my article seeks to clarify or to provide some examples of cases when you can see this tension. And probably the main one, which I think is really more apparent, is the idea and the notion of humanitarian intervention and the responsibility to protect. Because if you think about humanitarian interventions are instances of use of force, so basically violating, in a way, negative peace. You have a military intervention in another state. In the case of humanitarian intervention, is also without the invitation of the state or without an authorization by the Security Council, and you do it because you want to stop the commission of atrocity crimes. So there is this idea that to promote positive peace, you actually violate, in a way, so you promote positive peace to the detriment of negative peace. So you use force to promote the respect of human rights. And one further development about this is that if you look at the definition of the crime of aggression, and if you look at the debates that took place in Kampala when the parties, and not only the parties, but when it was discussed the crime of aggression and the definition of the crime of aggression, you see that the debates aimed at avoiding the inclusion of humanitarian interventions in the definition of the crime of aggression. Because the definition says that a crime of aggression is something that should be a manifest violation of the UN Charter. And if you look at the debates, at the travaux préparatoires, you will see that there was explicit reference about humanitarian interventions. And also, if you look at the intervention by several human rights NGOs, such as Human Rights Watch, Amnesty International, they were saying, well, actually, we don't want to promote the idea that the crime of aggression encompasses also humanitarian interventions. And so again, there is the idea that if a state commits something that would amount to aggression, this should then be a crime under international criminal law when it's done to promote the respect of human rights. So there is this tension that you can see between negative peace and positive peace. There are also other examples, and I don't want to go too much into details, but hopefully you will read the article and you will see. But another example is, for instance, the right to self-defense and peace. Obviously, nobody denies that there is a right to self-defense in case one state is attacked. We also have something similar in domestic law. However, I just came back from 2 weeks in Ukraine, and while I was there, it was right after the election of Trump, who said, well, if Zelensky is serious about having peace in Ukraine, he should forget about Crimea. It's been 10 years. Crimea is Russian. And this was basically the premise of actually starting discussions around a ceasefire and possibly peace talks. Another question is, what is the tension here is between, on the one hand, international law saying, no, absolutely, occupation is unlawful, you have a right to self-defense, you should keep going. And on the other hand, maybe making concessions, but this is also a political choice, in order to reach peace. So again, we have this kind of tensions between negative and positive peace, meaning that positive peace will be, well, no, Crimea should be Ukrainian because it's unlawful. Russia occupied Crimea. But then on the other hand, if you actually want to stop the war, to put an end to the war, so to reach negative peace, then just give up Crimea. I mean, I'm simplifying, obviously, but just to give an idea. And then there is another example, which is about amnesties. Now, I don't know if you have followed the peace talks and the peace negotiations in Colombia. And during the peace negotiations, there was a huge debate, which is now also happening in Ukraine, about amnesties. Because usually, if you want to reach a peace agreement, well, one way to do it is to grant amnesties. But then, on the other hand, to grant amnesties to rebel groups, or in Ukraine to, for instance, Russian soldiers who committed war crimes, will be unjust. So again, we have a peace which will be unjust, so not promoting justice by granting amnesties, but amnesties actually are something that help you reach a peace agreement. And so I guess also because I just came back from Ukraine and I'm supporting the Office of the Prosecutor in prosecuting Russian war criminals or potentially Russian war criminals. Obviously for them it's unthinkable to have a peace agreement or any form of agreement with Russia that also includes amnesties. However, this is also something that will be discussed in the negotiations. And then we have another example, and then I will stop here because I also want to hear your thoughts and comments and also my colleagues. But one last example is about the right to self-determination. So in the case of the right to self-determination, the question is, on the one hand, if you don't grant to, for instance, national liberation movements the right to use force against colonial domination, alien occupation, racist regimes, you are promoting negative peace. However, this kind of negative peace, so absence of war, is to the detriment of the fact that you are violating the right to self-determination. And so promoting positive peace might include also the possibility of granting them the right to use force against, for instance, alien occupation and racist regimes. So I will stop here, and thank you for your attention.
Thank you very much, Chiara. You raised a number of topical issues, and I think we will leave the discussion for the end of the panel so that we can discuss the three presentations together. But I see many connections and threads to what will come later. Just one point, in discussing peace, you focused on the concept and many examples. We are not discussing here institutional mechanisms that the UN does envisage in this regard, but I think it's a good choice. It's not the moment, probably, although it's discussed to raise the issue of abolishing the veto or some such things. I think it's more productive to focus on this tension that you highlight in a different perspective, but maybe I'm wrong, and we'll get back to this later. So our second speaker is Professor Christian Tams from the Universities of Glasgow and Paris Panthéon-Sorbonne. He will discuss the binding resolution of interstate disputes, what role for the United Nations. Professor Tams is a specialist of international dispute settlement. Not only that, many other things, but too long is the list and I cannot go into details. He is, among other things, the co-editor of the standard reference commentary to the Statute of the International Court of Justice. He has written extensively on erga omnes obligations, on the law of treaties, and many other aspects, core aspects of international law. He's also a practitioner in international law and has first-hand experience in dispute settlement. So he's really the perfect speaker on this topic. Christian, please, you have the floor.
Well, thank you, Serena. It's great to be here. Very grateful to have been invited to return to Ferrara for what is my second visit, and I'm still astonished at the wonderful city and very grateful to be among you for this conference. Now, my talk follows on from Chiara's, and as Serena says, there are linkages, but I think there's also an element of zooming in. So I'm looking at a particular form of UN's work towards peace, and you could say that's the lawyer's favorite form of ensuring peace, a form of peace through law, and not just peace through law, which can mean everything, but peace through a particular form of applying the law, peace through settling disputes in accordance with international law, and by dedicated institutions that are to be guided only, really, by law in the regular setting. Binding dispute resolution, peace through binding dispute resolution, in other words. And in my title, I have tied this back to the United Nations and formulated it as a form of, if you want, interaction between actors that could be seen to be in a relationship. What role for the United Nations in this binding resolution of interstate disputes? What does the UN do to bring us closer to the ideal that disputes be settled in relation, well, in accordance with international law and with a binding outcome? Now, in putting this question in this way, I'm assuming that the UN would want to bring us closer to the ideal of binding dispute resolution in accordance with international law and not obstruct this. There are individual instances in which perhaps that can be doubted, whether the UN really always works towards more binding dispute resolution. But overall, I think my starting point is a valid one, as the UN clearly cares about binding dispute resolution, the peaceful settlement of disputes in a binding manner. In fact, it cares a lot about this. It has great respect for the principle of peaceful settlement of disputes in accordance with international law, and the Charter reflects as much. I will briefly at the beginning revisit what the Charter says on this, and thereby, I think, establish that the UN has a positive vision of binding dispute resolution. That's not a controversial point. But after that, I want to inquire into the practicalities. What does the UN in practice do to make sure that peaceful dispute resolution in accordance with law is not just preached, but actually takes place? And I don't want to use too many spoilers, but I think my main message will be that the UN has perhaps not done as much as one could have expected 80 years ago when it was founded, to make sure that peaceful dispute resolution is a practical occurrence, not just a theoretical aspiration. So 80 years of UN practice, or the UN's life, if you want, you could say that the UN has transformed many aspects of international law and international relations. But as far as the binding settlement of disputes is concerned, I think we're relatively close to where we were in 1945, and that is my main and perhaps a sobering 80th anniversary message. So that's the opening. But rather than talking about the 80th birthday or sort of the today's perspective, let me start with the birth, 1945. What can we draw from a renewed look at the UN's establishment phase? It seems to me the picture is fairly positive we can derive from that renewed engagement. Fairly positive, not entirely positive as I will say, but fairly positive, because the UN Charter and the discussions that took place when it was adopted clearly bring out how much importance the UN attached to the principle of binding dispute resolution. And I think there are two aspects to this that seem very clearly agreed, which could be seen as building blocks of binding dispute resolution. First, with the UN Charter in 1945, the duty to resolve disputes peacefully, though not necessarily in a binding manner, but peaceful dispute resolution is massively upgraded. And the second point, there was wide recognition in 1945 that the best way of resolving disputes peacefully is by organizing dispute settlement procedures that are governed by law and that result in binding outcomes. And I think both points, which make up the idea of binding dispute resolutions, were very present in 1945. Now, I don't want to treat you or mistreat you to a detailed textual analysis of the UN Charter, especially because most of the provisions to us seem fairly well known. But let me run through a list of key provisions or key illustrations that bear out my two positive starting points. So, Article 1, Paragraph 1, the UN Principles. In the first operational provision of the Charter, the UN commits to, and I'm quoting, bring about by peaceful means and in conformity with the principles of justice and international law, adjustment or settlement of international disputes or situations which might lead to a breach of the peace. International lawyers have dissected the provision, including its limited scope, its only particular types of disputes that are targeted, but I would say, for my initial assessment, in the first operational provision of the UN Charter, we have a strong emphasis on peaceful dispute resolution and the need for this to be in conformity with the principles of international law. That's not such a bad starting point. It continues reasonably well, I would say. If we continue to read the Charter, we relatively quickly come to Article 2, Paragraph 3. That formulates, or I would say is today read to formulate, a binding duty of states to settle disputes peacefully. And I would say that's a significant normative upgrade to what existed before. Article 33 spells out means, and it shows that there are more than one means, and binding dispute resolution is not the only option. But still, the principle of binding dispute resolution is not just an aspiration, but a binding duty of states. This is, I think, relevant. And the normative upgrade, as far as substantive international law is concerned, is accompanied by an institutional upgrade. Again, 1945, the ICJ, as the main form of binding dispute resolution, is becoming a main organ of the UN, indeed its principal judicial organ. And the UN goes further and also recognized, you could say it encouraged in Article 95 of the Charter, the use by states of other tribunals for the settlement of disputes. So I think there's quite a presence in the UN Charter, if we look closely, of building blocks of binding dispute resolution. And perhaps most relevantly for our purposes, we see in the Charter negotiations much support for the idea that binding dispute resolution should enjoy precedence over other form of perhaps peaceful but not necessarily binding dispute settlement. It's most clearly expressed in the Charter in Article 36, Paragraph 3, which I think we don't read as much as we should, and which I therefore read for you now. In the context of the Security Council's Chapter 6 powers, we find a remarkable statement of principle, namely encouraging the Security Council, when it's dealing with disputes that endanger peace. The Charter says that the Security Council should take into consideration that legal disputes should, as a general rule, be referred to by the parties to the ICJ in accordance with the ICJ statute. So the idea is relatively strongly articulated there. Binding dispute resolution is not just one of a dozen means of settling disputes peacefully, but as a general rule, disputes about law should be referred to the ICJ. And I think 80 years ago that was very present, and it's perhaps not fully appreciated in retrospect. In the run-up to the Charter adoption, there was a rehearsal of prior debates. In fact, not just about the desirability of binding dispute resolution, but about the principle of general compulsory jurisdiction, debates that had taken place in 1907, in 1920, and again were rehearsed in 1944, 1945, 1946. And perhaps we can read those debates as a reenactment of the earlier great debates. It seemed to be at the time, 1907, 1920, 1940, something, every 10 to 20 years, states needed to go through the motions of assessing whether it was time to move to compulsory jurisdiction. And in 1945, a strong majority of states was keen to move to compulsory jurisdiction. I give you just two quotes to illustrate that point. The first comes from the Chinese delegate to the Washington Committee of Jurists, which prepared relevant texts, Mr. Wang. And he felt that what had narrowly been defeated in 1920, the idea of a general compulsory jurisdiction, should now be embraced. And he said that after World War I, governments were not ready to confer compulsory jurisdiction on the International Court, but now was the time for the change from the optional to the non-optional basis, a logical step in the course of world security, end of quote. And a Mr. De Castro from El Salvador said something similar and quite eloquently, reflecting the generally very strong support of Latin American states for the principle of compulsory jurisdiction, he said that most of the nations of the world are willing to accept compulsory jurisdiction, and he described the court as the greatest asset in the whole machinery of peace. Now, we know, and it's perhaps a bit cheap to be rehearsing those old statements, we know that it was not to be. Faced with Soviet and US opposition, the proposals for a general system of compulsory jurisdiction that would have entrusted the ICJ with a general mandate to settle disputes with binding force were abandoned. Contrary to Mr. Wang's assessment, the debates of 1920 would in fact be paralleled in 1945, and again, there was no general support to move towards a system of compulsory jurisdiction. We were stuck, and we remain stuck, with the idea of consensual jurisdiction that requires state support for the submission of disputes to the ICJ. But still, even if we factor that in, it seems to me from this cursory overview, I would say there is quite a strong emphasis on binding dispute resolution at the founding era of the UN, and an observer looking at the UN in 1945, I would have said, could have expected the UN to play a significant role in relation to binding dispute resolutions in the years to come. That observer may not have been sure whether the UN would reach its 80th birthday, or would live longer, or would be more short-lived, but I think an observer could have predicted quite a strong role for the UN in the field of binding dispute resolution. Now, with that, I move to the second part of my presentation. Has the UN lived up to that expectation of an anonymous observer of 1945? I'll have to be relatively sketchy in the 10, 12 minutes that remain. I cannot summarize 80 years of UN involvement, which is manifold and multifaceted. Some details will be in the paper, but I will step back for the next 10 minutes, not only so that I don't bore you with detail, but also because, I would like to positively connotate that. It seems to me sometimes when we read about the UN's role in dispute resolution, we have too much detail, too many trees, and no idea of the forest. So I'm stepping back, not just because of time, but also because I think I want to accentuate a few very big picture points. I want to talk about the forest and not the trees. So let me describe the forest of the UN's engagement with binding dispute resolution since 1945. And I think there are two main characteristics. The first is this: the UN has made an indispensable contribution to creating and maintaining an infrastructure of binding dispute resolution. But second, and that's perhaps more relevant, in my view, the UN is doing rather too little or less than could have been expected to induce states or to create conditions under which states could use that infrastructure. And I will briefly develop those 2 points before looking ahead. So first then, the positive. Let's start with the positives, as it were. It's a bit like professors in the UK. You must start with the positives now. Even if the essay is a disaster, unless you write half a page of what's good, students will complain and you will have to have a chat with your bosses. I don't know how it is in Italy. But so I'll start with the positives. The UN is making enormous and sustained contributions to the infrastructure of binding dispute resolution. And with infrastructure, I mean the basic facilities, including in a very concrete, tangible way, but also the concepts, the notions. Without the UN, we wouldn't really have the idea of this infrastructure. And I think we probably don't say it often enough in our writings on courts and tribunals and on dispute settlement, how much they depend on the day-to-day support by the UN and other international organizations. Let me mention a few concrete illustrations, and the focus in this and in the remainders on the ICJ. In the paper, I will speak about other forms of binding dispute resolution as well. So a few things, just almost like running through the list. The UN elects judges for the ICJ. It organizes the process. It hosts all the bazaar-style meetings where states present their candidates and try to get them approved. All this takes place within the UN. The UN ensures the day-to-day functioning of the ICJ through agreements with the Netherlands, with the Carnegie Foundation and the owners of the Peace Palace, by providing the ICJ and its members with immunity through agreements. Sometimes it fights for the court halfway through the 80-year period that we're now retrospectively assessing. The UN and the General Assembly seemed very keen to move the ICJ away from The Hague, something that nowadays seems unthinkable. But at the time, they felt the Dutch weren't supporting the court enough, and there was a threat that the UN would move the court away. And that's, you could say, either a mad idea in retrospect, or it was reflective of the fact that the General Assembly cared for its court. Now, the UN finances the court. Its 15 judges are paid by the UN, same for the 100-odd registry staff. No state needs to pay for the infrastructure if it goes to the ICJ for a contentious case. The UN organizes the employment structures, pays attractive pensions, and all this. And it's, in brackets, perhaps not very expensive. The UN has a total contribution of around 30 million euros to the ICJ per year. I suppose Ferrara pays more for most roadworks every month. So it's a cheap court, I would say, but still you could say the UN finances for it. And we can go further. The UN machinery not only provides for the court, it also receives and supports outcomes, decisions of the court. UN bodies ensure that ICJ decisions are received and disseminated. The UN emphasizes the need to comply with ICJ decisions. We talk about the Security Council enforcement power, but that's pretty much a dead letter in Article 94. I think what's far more important is the involvement of various UN agencies in ensuring that compliance is a reality. Think of cases, the Bakassi Peninsula case, or so Cameroon, Nigeria, one of the most dramatic judgments that the ICJ has ever rendered, where through 6 years of sustained UN pressure in the aftermath, Nigeria eventually vacated the peninsula. One of the big untold triumphs of binding dispute resolution, achieved largely through sustained UN pressure in the aftermath of the judgment. And I think if I'm concluding on this aspect, I would say we can say that the UN offers sustained support for the infrastructure in a broad sense of binding dispute resolution, as I've tried to show with respect to the ICJ. This is not nothing. But is it enough? Well, of course not, because the best supported infrastructure, the best supported court, would be lifeless if it did not have much work to do. And this brings me to the second aspect of the UN's involvement that I want to emphasize. Does the UN do enough to ensure that concrete disputes are submitted to the court or can be submitted to the court, whether the ICJ or others? There are obvious limits to what the UN can achieve. The ICJ, at least when we look at its contentious jurisdiction, which is, after all, where binding dispute resolution happens, is an interstate court. The UN cannot use the court itself, at least not the contentious procedure. But it can, of course, encourage those who can be parties, states. And it can ensure or try to work towards ensuring that states have access to the court, that the court has competence in many disputes. And it seems to me that in this second respect, the UN could do more and is too cautious, too focused perhaps on supplying the infrastructure and leaving the rest to others. What do I mean by that? Let me start with a fairly basic and straightforward proposition. Given the amount of energy and headspace devoted to the concept, notably by us international lawyers, rather few disputes are settled in a binding manner. The infrastructure to which the UN makes vital contributions is used surprisingly rarely, 80 years into the UN's life. Again, if I focus on the ICJ, it has had 195 proceedings in just under 80 years, contentious and advisory, two and a quarter per year on the most generous count. It's pretty disastrous. If we're lucky, we have 3 judgments per year, but on average we have 1.5 over the 80 years. We can talk as much as we want about the resurgence in the use of the court in the last few years, and perhaps we'll come to that shortly in the discussion or later in this course, but the statistics over 80 years are disappointing. And certainly they would have disappointed the UN founders, I think, who had high hopes for the ICJ. If we look into the reasons for the disappointing state of affairs, then 2 are usually mentioned. Jurisdiction remains limited, and even where jurisdiction exists, states are hesitant to use it. Does the UN have any role in this? In the spirit of a broad survey, let me again start by going back to the summary of debates from 80 years ago, when states opted against compulsory jurisdiction. We have been stuck, as is well known, for 80 years with consensual jurisdiction, with what the ICJ calls the fundamental principle of consent. And under the aegis of that principle, the ICJ's jurisdiction rests on special agreements, compromissory clauses, and optional clause declaration. And these need to be conferred by states, not the UN. But the UN is not without agency. It can exercise influence, and every now and then it does. But overall, it seems to me not to have fought hard enough for getting states to recognize the ICJ's jurisdiction. I make 3 brief points, and then I'm nearly there at the conclusion, Serena, in case you worry. The first point concerns the UN Charter. The treaty is setting up the ICJ and calling it the principal judicial organ. You could have expected, even in a system of consensual jurisdiction, that the Charter would refer certain matters for the court, for decision-making, that it would define, it addresses so many aspects of international law, why shouldn't the court's competence over some of them be established? After all, Article 36.3 says that reference to the ICJ would be the general rule for legal disputes. But the Charter does not. This is probably one of the weakest parts of the UN Charter. It contains no specific provisions, itself conferring compulsory jurisdiction on the court. It's always seemed to me to be a really missed opportunity. So all the ICJ competence has to come from outside the Charter. It's completely different for all other courts, but so it is for the ICJ. If we look at where the jurisdiction can derive from, then briefly on the optional clause. I would say the UN remains quite active, regularly nudging states to submit optional clause declaration. It's a standard feature of UN texts on the rule of law, on the decade of international law. Sometimes it's put in very emphatic terms. From my own memory, I can remember Boutros Ghali's Agenda for Peace, which was strong on encouraging states to submit optional clause declarations. More recently, the Security Council in the early 2010s has made presidential statements which are perhaps a bit of a faint echo. And the record is not so bad. 75 states have submitted such declarations out of 194. So it's not just a question of the decline of the optional clause, as the famous article says, but the UN doesn't really insist. It doesn't really hold it against states if they don't submit such declarations, and it doesn't do anything to curb the practice of ever larger reservations to the optional clause. So I would say okay support, but not very much. For compromissory clauses, treaties that establish the ICJ's jurisdiction over generally defined types of disputes, things are slightly different. That's today the most important source of ICJ jurisdiction, and typically these clauses derive from treaties that states have negotiated and accepted multilaterally under UN auspices, with UN influence. UN experts prepare draft texts. They are the secretariat. They can influence matters, and they certainly are there to sustain treaty-making efforts. You could say that's a good opportunity to get states to incrementally increase the scope for binding dispute resolution. And for decades, the UN was quite consistent in arguing that multilateral treaties should have ICJ compromissory clauses. But it seems to me that the UN has really given up a bit on that. For the past 3 to 4 decades, so if you want the second half of the UN's 80 years, including during times of massive UN ambition, or you would say hubris in retrospect, multilateral treaties have no longer really contained straightforward compromissory clauses. The ICJ may still be referenced in the text, but it's not the natural, indispensable forum for dispute settlement. There are opt-in procedures, opt-out procedures, but the idea that you would have a standard, straightforward compromissory clause is gone. The picture is really quite bleak. No clause negotiated since 1970 in a multilateral treaty has ever been invoked before the ICJ. The clauses that exist are the old ones: Genocide Convention, Vienna Convention on Diplomatic Relations, Consular Relations. That's where the case law comes from, not from new clauses. So to conclude, I don't think the UN has kept the faith on that. It has stopped encouraging states to keep the faith of increasing incrementally the scope for binding dispute resolution. There's one major exception, UNCLOS, which we can discuss, but otherwise the jurisdictionalization of international law has been driven by outside the UN, regionally in the WTO, but not from within the core of international law, the UN's core of international law. So the UN has accepted that consensualism rules, and it has lost the drive a bit to states to expand the reach of consensual jurisdiction. My final point, what about concrete cases? Does the UN use its influence not to expand the reach of jurisdiction, but to get real cases onto the court's docket? I think on this, the picture is not so bad. Of course, the numbers are ridiculously small, but relevant numbers of cases are brought to the ICJ or to other courts under UN-sponsored treaties because the UN proposes this as part of its own dispute settlement efforts. I'll develop this in the paper. Many territorial disputes reach the court because in lengthy UN-assisted negotiations, states eventually agree to a compromise which refers the matter to the ICJ. There's also, to facilitate this, the Secretary General's Trust Fund, which allows states to defray some of the costs of binding dispute resolution, their own council costs. So the UN makes efforts, but I think it is not as forceful as it could be. So where does this leave us? A one-minute conclusion. Ricardo, you mentioned the terms, resilience, change, continuity. I think there's an element of resignation that I would like to add. Well, resilience, of course, in preaching the principle, but I think resignation in coming to terms with the fact that binding dispute resolution is for state consent to determine. Perhaps an element of resignation that the high hopes expressed in the first half of the 20th century of placing so much effort on courts as the core dispute settlers has been misplaced, and a resignation that perhaps it is something that is for the Sunday sermons, and occasionally we nudge states if they're small and willing and care to listen. The UN nudges states to go to a court, but I don't think this is a sustained practice. For the next 20 years that stand between us and the centenary advantage, maybe the UN can be encouraged to be a bit more ambitious, a bit broader, a bit more ambitious in its drive to get states to use binding dispute resolution procedures. If it did that, I think it would reconnect with the spirit of the founders and drafters. Thank you.
Thank you very much, Christian. I would like to discuss right now, but I will refrain and just introduce our third and last speaker, who is my dear colleague and friend, Alessandra Annoni. She is professor of international law here at the University of Ferrara. She has written on many aspects of international law, including institutions that are of long-standing tradition, bringing new light and life to them. I refer to her books on hostile occupation and on recognition as a unilateral act of state. In her writings, she always manages to apply sharp logic to apparently very confused situations, and through that she lets us understand a bit more about international law and how it works and should work. So I'm sure she will also help us navigating the conundrum of her, that is the topic of her presentation, the United Nations and the International Criminal Court, navigating the persistent tension between peace and justice. Alessandra, the floor is yours.
Thank you, Serena. I would like, first of all, to join my co-panelists in thanking the scientific committee that organized this conference, and also my colleagues here in Ferrara who took care of all the organizational issues, therefore lifting me, relieving me of all the burdens that normally come with the organization of a conference in your own university. So I feel really privileged in being here just to speak. Coming to the topic, the ICC statute was negotiated under the auspices of the UN. The mandates of the two institutions, the UN and the ICC, are deeply interconnected. The ICC was established to deal with the most serious crimes of concern of the international community as a whole. And as recognized in the preamble of the ICC statute, such grave crimes threaten the peace, security, and well-being of the world. Maintaining and restoring peace and security, whatever that means, is the core business of the UN. And as explained in the commentary to the 1994 draft version of the statute prepared by the International Law Commission, divergent views emerged among the members of the Commission regarding the way the court should be instituted and how its relationship with the United Nations was to be shaped. Some members proposed to create the court as an organ of the United Nations by amendment of the Charter. Some others proposed to create the court as a subsidiary organ of the United Nations by way of resolutions of Security Council and General Assembly. Ultimately, for reasons that I don't really have the time to explore today, the court was established by treaty as an independent permanent institution. It was clear, however, that this court, albeit independent, had to come into close relationship with the United Nations. Now, this relationship nowadays is governed by a complex legal framework. We have, first of all, the principles and purposes of the United Nations Charter, which are reaffirmed in the preamble of the ICC statute. The Rome Statute itself includes a number of provisions regulating different aspects of the cooperation with the United Nations. I'm referring, for instance, to Article 13 and 16 of the ICC Statute, referring to referral and deferrals by the Security Council. And then Articles 15 bis and 15 ter that provide for specific rules applying to the crime of aggression, and they grant the Security Council a role not only when the jurisdiction of the court is triggered by the Security Council itself, but also in cases of state referrals and proprio motu action by the prosecutor for the crime of aggression. Then we have, of course, Articles 15, paragraph 2 and 87, paragraph 6, that provide for the general framework for judicial assistance by UN organs to the Office of the Prosecutor and to the court itself. And last but not least, we have Article 115, according to which funds provided by the United Nations are one of the two sources of funding to cover the court's expenses. But most of all, we have Article 2 of the statute, according to which, I'm quoting, the court shall be brought into relationship with the United Nations through an agreement to be approved by the Assembly of States Parties and concluded by the President of the Court on its behalf. This relationship agreement was concluded by the two institutions in 2004, and it entered into force on the 4th of October 2004. This is a framework, a pretty comprehensive framework regarding the cooperation between the two institutions. What I like to highlight, first of all, is Article 15, paragraph 1 of this agreement, whereby the United Nations, which are not a party to the ICC statute, undertake to cooperate with the court and to provide to the court information or documents and any other form of cooperation and assistance which is compatible with the provisions of the Charter and the statute. The United Nations themselves try to clarify even further this legal framework by issuing a best practices manual for United Nations and International Criminal Court cooperation, which was issued in 2016 and helps clarifying some of the provisions of this relationship agreement. The relationship agreement itself provides for the possibility of supplementary agreements to be concluded by UN organs, including peacekeeping operations, with the court to facilitate cooperation. As we shall see, memorandum of understanding have been concluded on the basis of these provisions with peacekeeping forces to facilitate cooperation between peacekeeping forces and the ICC. And then we have another group of special agreements concluded by the Office of the Prosecutor and by the Registry of the ICC with various UN bodies to clarify specific aspects of this cooperation. Now, the purpose of my paper would be to assess how this complex legal framework works in practice, exploring the evolving dynamics of the UN-ICC cooperation in the light of the persistent tension between peace, again, whatever that means, which is the core business of the UN, and justice, which is supposed to be the objective pursued by the ICC. In my written paper, I will try to address different aspects of this relationship. However, today, given the limited time at disposal, I will only try to focus on two case studies, which I consider illustrative of the challenges that may arise, but also of the potentials of the cooperation between these two institutions. And I will address, in turn, first, the dynamics of referral and deferral in the case of Sudan, and second, the practice concerning cooperation between UN peacekeeping operations and the International Criminal Court in the light of the specific case of Congo. So, first of all, the dynamics of referral and deferral in the case of Sudan. As you all know, with its resolution 1593 of 2005, the Security Council referred to the court the situation in Darfur since the 1st of July 2002. The prosecutor started investigating on this case and asked for the issuance of arrest warrants. The pretrial chamber issued arrest warrants in different cases, including Harun, Hussein, and, of course, al-Bashir, the standing president of Sudan, the standing head of state of Sudan. On the initiative of the African Union and of some African states, a draft resolution asking for the deferral of the al-Bashir case was tabled for discussion in 2009 before the Security Council. However, due to opposition by Western states, the resolution did not pass, and therefore there was no deferral under Article 16 of this case. This raised many protests by African states, and also in particular by South Africa, but not only. But what happened later was that many African states refused to comply with their obligation to cooperate with the court. In particular, they refused to transfer Mr. al-Bashir to The Hague, even though he was traveling nicely on their own territory. And this applies to Rome Statute states, member states. What did the Security Council do at this point? Well, not much. It did not take any action, even if it could have done so, because the court itself stated that this behavior by African states was a non-compliance with ICC obligations, and therefore the Security Council was in a position to sanction, even apply sanctions even to those states, and yet nothing happened, notwithstanding a number of requests by the Office of the Prosecutor and by the President of the Court to this effect. So what lessons can we learn from this case? Well, the court has remained true to its role of ensuring accountability, of ensuring justice. The investigations by the Office of the Prosecutor started as requested by the Security Council. The court issued the arrest warrants based on the evidence that emerged during the investigation, focusing on the major perpetrators without considering their official capacity as explicitly provided under Article 27 of the statute. It has also condemned the lack of the court has also condemned the lack of cooperation by state parties as provided under the statute. The potential conflict between peace and justice due to the fact that a sitting head of state was charged with crimes before the ICC was raised and debated in the appropriate forum, which is the Security Council. However, if we analyze the discussions within the Security Council when the draft resolution on the FERA was tabled, we realize that the discontent of African states towards the court was more linked with the discontent with the court itself, for the fact that the court was perceived as biased. And these arguments carried more weight than any genuine concern that Bashir's arrest might negatively impact peace negotiations in Sudan. After referring the case to the court and refusing to defer the proceedings against al-Bashir, one would have expected the Security Council to react when member states refused to enforce the arrest warrants. This, however, did not happen, and this obviously undermined the authority of the ICC itself. Turning to the second case, the cooperation between UN peacekeeping forces in Congo and the ICC. Now, in many situations which are now before the court, peacekeepers have a unique access to the territory, and they would be in a perfect position to provide assistance to the court. We have peacekeepers in Sudan, we have peacekeepers in Congo, in Cote d'Ivoire, and elsewhere. The type of cooperation that UN peacekeepers can offer is manifold, ranging from logistical support, transport, supporting communications, the provision of information, documents, interviews, testimonies, the preservation of evidence, the tracing of witnesses, assistance with searches, the provision of security and access for the purposes of ICC on-site investigations, up to the enforcement of arrest warrants and summonses. The degree of cooperation of peacekeepers with the court, however, is different in the different cases. The decision on whether and how to assist the ICC ultimately lies with the mission leadership, which is the special representative of the Secretary General, the head of the mission, together with the force commander and the director of Human Rights Office. As highlighted in a recent book by Tom Butelaar, titled Assisting International Justice Cooperation Between UN Peacekeeping Operations and the International Criminal Court, the book that was published in 2023, the decision of the head of the mission is influenced by a number of factors. First of all, the mandate. Peacekeepers are deployed on the basis of a mandate which is included in a Security Council resolution. Has the Security Council granted peacekeeping forces with a clear mandate to support the ICC? Are they able to use force to support the ICC, for example, to enforce an arrest? This is a first issue. Is there a memorandum of understanding between the peacekeeping forces and the ICC, where a high volume of requests for cooperation are anticipated? Usually the ICC would ask the UN to conclude such an agreement, such a memorandum of understanding. We do have memorandum of understandings for Congo, for Cote d'Ivoire, for Mali, and for the Central African Republic. But not all memorandum of understandings are equal. There are memorandum of understandings that are very clear on what kind of cooperation is expected by peacekeepers, and others that are less clear. Capacity. What are the men and what are the assets of the peacekeepers on site? Because, of course, you need assets and men to enforce cooperation. And then, of course, there are political concerns. What is the, well, one of the factors that have to be factored in is, of course, has to do, of course, with peace concerns. Does the local government agree on the cooperation with the ICC? Because peacekeepers are deployed with the consent of the local government. So without that, it's very difficult to cooperate. What impact would the arrest have on peace negotiations if there are peace negotiations ongoing in the field? What risk would there be for force protection? This is also an issue that the commander of the peacekeepers has to take into consideration. And obviously, the impact of all these factors changes depending from the type of cooperation that is requested by the court. Because one thing is to share information, quite a different thing is to arrest a suspect and transfer him or her to the court. The case of Congo shows that all these factors may change over time, the mandate may change, security concerns may change, and also peace concerns may change, and they have to be factored, all these factors have to be factored in all together, leading to a case-by-case assessment. At the outset, the mandate of MONUC, the peacekeeping forces in Congo, was not very clear. If we read Resolution 1565 of 2004, there's a paragraph 5G, whereby, I'm quoting, the peacekeepers should continue to cooperate with efforts to ensure that those responsible for serious violations of human rights and international humanitarian law are brought to justice. But brought to justice where? Before a domestic court, before an international court? The ICC is not mentioned. And brought to justice how? Can peacekeepers use force to bring these people to justice? So it was not very clear. There were not specific capacities given to the peacekeepers to enforce cooperation with the courts. At the same time, the risks for stability were fairly low. When the prosecutor arrived in Congo for the first time, he made it very clear that he was going to concentrate, first of all, on the crimes perpetrated in Ituri. The government of Congo supported this endeavor for justice in this area of the conflict. Perhaps it would not have supported it in other areas of the country. So there were not particular risks for stability. There were no peace talks ongoing. What was the outcome? Lots of information sharing. Peacekeepers helped in many different ways the ICC. They provided logistical support for security. They even enforced a witness protection program on site to protect witnesses before the ICC. They were involved, peacekeepers were involved in the transfer of Lubanga Dillo to The Hague. Lubanga Dillo was not arrested by peacekeepers, he was arrested by Congolese forces, but he was transferred to The Hague by peacekeepers at the request of the Congo government. The peacekeepers also tried to assist in arresting suspects wanted by the ICC. They tried. They tried to arrest Otti, who was a member of the Lord's Resistance Army, an Ugandan rebel group, and this enjoyed great political support by the government of Congo, even though the operation was not successful. However, things changed over time in different ways. In one way, the mandate became much clearer. If we look at resolutions adopted by the Security Council in 2010 and 2011, well, the mandate of the peacekeepers is much clearer. I'll read just a part of the resolution 1991 of 2011. This resolution creates an intervention brigade within the peacekeepers and explicitly authorizes this brigade to support the local government in arresting and bringing to justice those responsible for international crime, including through cooperation with the ICC. And this part of the resolution also states very clearly that peacekeepers can use all available means, and we know what that means in the language of the Security Council. That was, of course, a memorandum of understanding. The framework was much clearer because in 2005, a memorandum of understanding was concluded. So all the way, the procedures to obtain cooperation was also clarified. There was great capacity. The intervention brigade was there not only for, but also to support investigations by the ICC, to support the ICC in general. However, the risk for stability was very high at that point. Peace negotiations were ongoing, and the ICC wanted individuals that were active part of these negotiations, and this was an issue. The agreement of the local government was also shaking. The government was saying plainly that it supported peacekeepers helping the ICC, but at the same time, behind the scenes, it was not particularly happy with them doing it. So what happened? What was the outcome? There was great cooperation in terms of information sharing, etc., but very little cooperation in terms of arrest. For example, Bosco Ntanga, one of the main persons that was wanted by the ICC, walked around in Congo in plain sight of peacekeepers, and he was never arrested. Now, coming to, if I have 2 minutes, just to the conclusions. What conclusions should we draw or try to draw from these 2 case studies? Well, peace and justice are core values of the international legal system. This is clear, and there is no reason why one value should always prevail or take precedence over the other, particularly if we consider peace as positive peace, as we were discussing before. Positive peace includes accountability, includes justice. There are, however, situations where pursuing accountability in a specific moment, in a specific scenario, may endanger or delay, at least, peace or absence of conflict, rather. But what should happen then? I think what is necessary is a clear distinction of roles, first of all. The UN has a role for peace, the ICC has a role for justice. And I consider particularly dangerous all attempts to reread the statute as allowing the prosecutor to factor in peace when deciding whether to issue an arrest warrant or proceed with investigations under Article 53 of the statute. The interests of justice are not the same thing as the interests of peace. They are 2 different concepts. At the same time, while respecting this division of roles, the ICC and the UN should try to operate in an integrated framework, supporting each other in order to foster a balanced approach with the aim to achieve global stability, positive peace, and they should do so making use of all the tools that are available under the statute and under the UN Charter. So deferrals are fine, they are provided under the statute as long as they are temporary. The statute allows the prosecutor to make choices when it comes to prioritize the investigation efforts in a given situation. The case of Congo, the first case, is a good example of how a dialogue between the UN organs and the Office of the Prosecutor may help in this respect. Concentrating on Ituri was a way to allow the court to do its job without endangering too much peace prospects. Not using peacekeeper to enforce arrest warrants in particular situations may also be a good thing, not to undermine stability, as long as peace plans take into account justice. This has to be a condition. What is the challenge of this, at least one of the challenges of this integrated system? Well, one of the main actors in this integrated system is the Security Council. In most cases, it is for the Security Council to balance peace and justice. Deferrals, referrals are in the hands of the Security Council. Shaping the mandate of peacekeepers is in the hand of the Security Council. Deciding on sanctions for those who do not comply with arrest warrants is with the Security Council. And we know that the composition and voting mechanism of the Security Council is an issue because it does not reflect the current geopolitical complexity, because members are often animated by individual interests, as the African states in the Sudan case, rather than by genuine intent to strike the balance between peace and justice, but also because the voting system within the Council structurally facilitates inertia rather than action. It's much easier not to adopt a decision before the Security Council. You just need one permanent member to use its veto power rather than to adopt one. And this can create inconsistency even with the same situation, as in Sudan, no deferral and yet no sanction for states that do not cooperate with the court. So I think that the dialogue between the ICC and the UN, a dialogue that tries to balance peace and justice, is better achieved outside the Security Council, within a direct dialogue between UN organs. I took the example of peacekeepers, but it could be even other UN organs, and the ICC, the Office of the Prosecutor, and the other bodies of the ICC. And this is the place where probably peace and justice can be better put together in an integrated framework. Thank you very much.
Thank you very much to Alessandra, but also to the other speakers for excellent, stimulating presentations. And thanks also to Santiago's absence. We have plenty of time for discussion. I wonder if there's any questions from the floor. Oh, okay. Cristina Gavrish, University of Ferrara.
Thank you, Sacerdoti.
Giorgio Sacerdoti.
I have two questions for Professor Thams. The first one is when you say the UN should do, doesn't do, is expected, whom do you add as the Secretariat, the staff, the Security Council, the General Assembly, or the sociological environment, etc.? The second question concerns the International Court of Justice. You tend to say that the court is underused. In fact, there have been many, many years in which it is very slowly used. When I was a student, to find that there was one new judgment of the court was prime. But now, isn't it, or some people say, there is an overutilization of the court for disputes which are not really disputes, that is conflict of interest like a border dispute or an immunity dispute in Germany, but it's a lawfare, a political use. These cases under the Human Rights Convention, Azerbaijan, Armenia, also the one Ukraine, Russia, and even the one you have been involved, I have followed you on the screen, Nicaragua versus Germany. They are, I don't say they are fake cases, but they are to make political point, to embarrass another country, or I don't know, you know better. So maybe the courts, and if the court, this court, and possibly others, are used not for the scope for which they were intended, this will increase the backlash of states being reluctant to accept ex ante jurisdictional clause of compulsory jurisdiction, even on a voluntary basis. Thank you.
Please, Anna Viterbo, and then Professor Ronzitti.
Thank you. I have a question as well for Christian Thams. I wonder, focusing on the consensual basis of the jurisdiction of the ICJ, whether you are going to take into account also the unilateral declaration of acceptance of the court jurisdiction, not in general, but specifically looking at reservations made to those unilateral declarations and how this works when those unilateral declarations contain reservations that are in nature self-judging because they are referring to national security issues or this sort of things. There are a few. I have India in mind, but maybe some other countries as well.
Thank you. And then Professor Ronzitti, and then we'll have answers and then a further round. Please.
I have questions or comments for all three speakers. The first is about Professor Radaelli and about the usefulness of this notion of a positive peace. But I have seen, at least hearing you, that in some cases, positive peace is at the expense of a negative peace. For instance, if you have a humanitarian intervention, if you have the implementation of a self-determination by using a force. And you can have also a revolution in a country for having human rights. And I didn't hear nothing about domestic violence, if the violence within a country is a notion which should be kept in mind for positive peace. So I wonder whether this notion of a positive peace is just an intellectual notion, but I'm very skeptical about its usefulness for maintaining a peace and the security, because up till now peace has been negative peace. Positive peace, human rights, and the self-determination and so on are another things, but it's difficult, very difficult to make a linkage between the positive and the negative peace. This is my problem with the negative peace. With Professor Tams, that there are plenty nowadays of settlement of disputes mechanism. But the question to you is that without amending the Security Council in the Charter, because it's very difficult, it's impossible to amend the Security Council, do you think that some provisions of the Charter on the settlement of disputes should be amended? For instance, the problem of implementing International Court of Justice judgments. In this case, this article of the Charter should be amended, or is just a dormant dog? It should be better that it stay there as standing up till now. And so on can continue. For instance, for Article 27, paragraph 3, about the abstention of the member involved in a dispute and so on. And for Professor Arnone, I would say, I'm very skeptical about this international justice administered by international court, international criminal court. Up till now, the court incriminates also only people from African countries. Nowadays, the court is doing something else, and we have Putin and Netanyahu on the ship. But we have seen that some of these countries are challenging the court, taking sanctions or countermeasures, whatever you want, against the members of officials of the International Criminal Court. But this is unbelievable from the point of administrative of justice, because this happens, for instance, in domestic order, but only the domestic criminal association which takes sanctions, so to speak, against the judges, not the government or other powers legitimately governing this country. So if you can say something about this practice of having sanctions taken against judges of the International Criminal Court. Of course, it's a violation of international law, question mark, but just a violation is not enough. Thank you.
Thank you. I would.
Space for one last question.
I think we would like to have a round of answers, and then we give you the floor. So keep the mic. You will be the first later. I may just add a short comment to what Natalino Rozzetti was saying. There are sanctions threatened or enacted against judges and prosecutors. There are reactions, very negative reactions against peacekeepers. There are decisions, for instance, by the US legislature to withhold funding, not only from the UN as such, but from the ICJ specifically as a reaction to certain decisions that were not liked by the UN government. So maybe this resistance by states should be somehow taken in and factored into the big picture. And yeah, maybe your comments on this as well could be welcome. I would go in reverse order. So we start with Alessandra and then Christian and then Chiara.
Thank you, Professor Rozzetti, also because you gave me the opportunity to come to talk about something that will be on my paper, but I didn't address in the presentation. What I started to wonder about is, given that this situation has arisen, given that there are states that have started threatening or inflicting sanctions against judges and prosecutors of the court, my question was, what has the UN to say about this? Is it something that is against international law? It is something that somehow should be of concern for the United Nations, given the relationship that the United Nations has with the court. Well, what struck my attention was the fact that on the 28th of October, 2024, in her annual report to the Security Council, the president of the ICC, of the International Criminal Court, stated, I'm quoting, "All United Nations member states must take action, both individually and collectively, to prevent a situation where the court's operations cannot continue by taking preventive and responsive measures against threats directed to the court." Now, I read this statement as a call to the UN Security Council, to the UN in general, to support the work of the court, but to the UN Security Council in particular, to use Chapter 7 tools to react against these violations. It was a statement before the Security Council, and there is a relationship agreement between the court and the Security Council. There is a relationship between peace and justice, so maybe when the court that is there to enforce justice, but also as a tool for peace, when the court is endangered, maybe this could be qualified as a threat to peace. And if it's a threat to peace, then reactions can be taken by the Security Council. I know it's a big stretch, but my feeling was that the way the argument was put forward before the Security Council was somehow trying to get the Council think about this possibility. Of course, again, it's the Security Council. So what I was saying before about the voting methods, etc., fully applies here. I do not expect the Security Council to adopt sanctions against the United States for inflicting sanctions on the ICC. But I think this is one issue, how if the court is really a tool to peace and not only a tool to justice, then threatening the court is a threat to peace. It has to be qualified as such, I think.
Thank you, Alessandra. Christian, please.
Thank you, Serena. Thanks to my colleagues for these questions. They are broad-ranging. Let's see how comprehensive I can be in responding them. I'll go in the order. So, Professor Sacerdoti, I think you had two questions, and I think the first, I think, identified what I would say is the main weakness of my presentation. You may have spotted other weaknesses, but one I am very conscious of, that I have spoken about the UN without really saying whom I mean, and I think you mentioned that. I think you offered various options. I think I would probably lean towards your last option, a sociological referent for people involved with the UN project, and that is, of course, very fluffy and very non-definitional. I had in mind, when I was talking about UN inaction or UN efforts, three aspects, I think. One is the structured processes of UN decision-making. So I would draw on presidential statements in the Security Council, General Assembly resolutions that would encourage a particular form of dispute resolution, but I wouldn't reduce it to that. I would also think of the work of UN staff, mostly then Secretariat, in the drafting of conventions. That's what I drew on. And I think then I also drew on issue position papers by the UN Secretary General. I haven't really clearly distinguished between them. I think the one distinction I would draw is that I was looking at emanations of the UN process that are separate from the member states' positions. So I think in that sense, that's probably the only thing that holds my notion of UN together, but I appreciate that I will have to refine that as I proceed from the presentation to the paper. Your second question concerns the ICJ and lawfare and the trend of cases that seem to be different from classical cases. And I think I share some of the concerns that you articulated. These are indeed challenging cases for respondent states, but also for the court, and perhaps for all of us looking at the court. And I think I also share your perception that very often these are cases that are not brought with a view to winning the legal argument, but perhaps, or directly obtaining a pronouncement that lets the applicant state win the legal argument and therefore obtain redress, but for other motivations. But it seems to me we're all still struggling to come to terms about what they are really then about and whether that other thing that they are about is problematic. So take, I think you mentioned mobilization or activism, or some people say it's strategic litigation, and that may be true, but I'm not so, I'm not so sure this is so dramatically different. The difference may be one of degree. If states have threatened to go to the court in other matters, it's often been to escalate a dispute settlement process or change the dynamics of a dispute settlement process, or even to shelve a dispute settlement process. It's always, even in the old days, for the very classical disputes, it was, for example, said that Mr. Gaddafi in the old days agreed to bring the dispute with Chad to the ICJ as a way of buying time and regaining international reputation. That's very different from what Nicaragua has in mind, but I think it's also similar in that it cannot really be explained in our traditional orthodox account of dispute settlement as the next step after diplomatic procedures for dispute resolution. So I think maybe the court's cases have always been a bit more diverse. I nonetheless share your concerns. I'm citing one statement from a judge at one of the centenary celebrations of the Hague Academy when he said that he wished the court many cases, but cases where the court can actually do something. And I can't reveal the name, but I think that I think captures your concern, which is my concern as well. Let me nonetheless take 30 seconds to say why, on balance, I think we should live with that and perhaps live without despair. On the one hand, I don't really see what we can do as observers other than perhaps voicing concerns. It'll be for the court to define categories to if you want, leave out those cases. And so far, the court has consciously resisted on all fronts. Abuse of process is completely a non-starter as an argument. The argument that these are political cases or that politics influence the legal aspect, the court has always resisted that for half a century. And the idea that you couldn't single out specific aspects of a dispute because they were intertwined with broader aspects for which the court has no jurisdiction, the court has pretty much in every second case rejected that. So I think I would say let's leave it to the court, let's leave it to the court to find if you want, red lines and deal with them. My own view is that we have had a century of underusing the court and not using the court for the real disputes that we care about, so we can probably live with 10 years in which the court is a bit dubiously used for disputes that we do care about. And I would go into this new phase with an optimism of experimenting with the notion of the court, because it's been pretty underwhelming for a century, so we might as well try new things. That was a long response to your two questions, but they were broad and wide-ranging. I'll be more brief in my other responses. Professor Viterba, oh, there you are. Sorry, I didn't see you. Thank you for your question on reservations and how they relate to the point, or reservations to the optional clause. I think, to just recapitulate, I think my concern is that the UN has continues to plead in favor of more optional clause declarations, but is happy to count the numbers. So they will say, oh, it's 75 now, we're approaching 80, and they define even targets in the UN legal office. We want to get to 80 or close to 100. And then they fail to do what you have done now, say, well, look, what's the Indian declaration worth with all its sort of 20 pages of reservations? Or think of Iran, which has now submitted an optional clause declaration, which is optional, but only singles out things that it wants to litigate. So I think there's a need to curb that more. The self-judging nature is probably the only reservation, or the self-judging reservation is probably the only one on which there has been pushback to the point where states seem either no longer to include it or have not invoked it. And I think that's the only resistance, but it's on such an absurd reservation that I think it doesn't affect my overall assessment that the UN should do more to push back against reservations. In that sense, I think I share your concern. Finally, Professor Ronziti, you were the fairy giving me the wishes. If I could change the UN Charter provisions, do I have 3 wishes or 2? I don't know. You'll have to tell me. I think I would not waste my wish on Article 94, the Security Council. I think it seems to me that the current situation is not captured by Article 94. The Security Council is unattracted to enforcing ICJ decisions, and the ones that we would want Security Council support will never get through the Security Council, because the Security Council will have its proxies involved in the court. So I would think my hope for Article 94 would be more that there's more compliance-inducing activity that is not captured by Article 94. And this is, I think, what is happening all the time when the General Assembly recommends enforcement of ICJ decisions, or the Secretary General offers his good offices. I would build on that and would hope that this would be a regularity. I don't see any chance to do more than that. Article 27, I think I would see more virtue in a clarification, and I think there would have been a good case to say that, let's say, decisions on on ICJ decisions should be not subject to the veto of the permanent members in the sense of Article 27, paragraph 3, but the institutional practice of the Security Council since the Nicaragua case seems to speak against that, and the UN legal office seems to have accepted the practice. Maybe my wish would be for that debate to be reopened. So that's my cautious use of your wishes. Thank you.
Thank you. And now, Chiara, please.
Thank you. And thank you, Professor, for your question. And actually, this is also something that I've been thinking about. I don't think that positive peace is necessarily the way in which it's used now, a positive trend or development. I think the trend is there. So this tension between kind of promoting negative peace and promoting human rights or justice to the detriment of peace in the sense of absence of war is happening to some extent. And I don't think that this is actually a good development. However, there isn't really a debate around this tension and around these notions and what's happening. So the objective of my paper was mainly to highlight this tension and this new trend. But after and drawing upon your question, maybe it might be useful also to add something to say, by the way, this is happening, we should talk about it, this is the direction, do we actually like it? And just one thing with regard to domestic violence, there is a debate around the existence of the right to rebel. I also published a few things on that. And this is also something which is a bit of a worrying development. Now, when we talk about negative peace, usually the idea also, if we read the UN Charter, is about use of force between states. There isn't really a prohibition to start a rebellion, at least from the rebels. For the state, we have human rights law, so it's different. But this is also important and something that should be regulated at some point, especially if we think about the fact that the vast majority of armed conflicts right now are non-international armed conflicts. And yet, because of the origins of the UN Charter and the international law after the Second World War, armed conflicts, non-international armed conflicts were not really at the center of legal debates, and we still pay for this in a way. So thank you for your question, and it's been very useful to, I will integrate this in the paper. Thank you.
Now it's time for a second round. We have Christina Gavrish first, and then those in the lines there. Okay. Okay. Yeah, maybe we'll have 3 rounds. So please, Christina.
Many thanks for the presentations. My question is for Alessandra Agnoni. I was just wondering whether the notions of peace are discussed. Microphone. Is it oh? Nice. Do you hear me right now?
No.
No.
Maybe you should come here, Christina. It could be that the batteries are out.
Maybe it's just in standby.
Okay, so thank you. I was just wondering whether the notions of peace discussed today may also be effectively pursued within ICC itself, maybe through the principle of positive complementarity.
And then, Christina, maybe this is working, so you can pass it along.
Thank you very much. Eleonora Branca, Roma Tre University, Mediterranean University of Reggio Calabria. Thank you very much to all the panelists for their very thoughtful presentation. And my question goes to Chiara Radaelli. Thanks for this fascinating tension between negative and positive peace. My question is actually on one of the UN tools to preserve or bring peace, which has been much talked about also by Alessandra, peace operations. So the question is, to what extent you imagine the impact of your discourse on a possible, do you think that there's a need of a reform of these tool of the UN, which is not very much in good shape? If we look at the current practice, they've not very much resorted to, as we used to know, peace operations led by the UN. And do you think that we'll see a resurgence of all these courses like peace enforcement? Are you thinking of going in that direction or in different avenues? Thank you very much.
And then we have Carlo, I think, or who was?
Thank you. Carlo De Stefano, Roma Tre University. I have 2 quick questions for Professor Thams. So you referred to Article 36, paragraph 3. And my question is, what is the relationship of this provision with Article 33 in its entirety, in which we find the principle that states are basically free to choose the means to settle their legal disputes? And second question, and since it seems we have also time, you referred to hubris, Professor Thams. So can you further elaborate on that? Thank you.
So I would organize this round of answers, and then we go back to the next questions. I think we start with Chiara Vedorelli this time.
Yeah. Thank you for your question. And yeah, I've been thinking about peace operations. I'm still thinking about it, which is why I didn't include them in the examples I gave, also because maybe they require a bit of a longer discussion. Now, I'm not really in favor of peace enforcement in general, meaning using force to enforce peace. I'm not sure if this is actually something that will be successful necessarily. And sometimes I have the impression that trying to enforce peace in this way doesn't necessarily mean that actually peace is achieved. Sometimes it actually leads to increased violence. So actually it goes in the opposite direction. Potentially, and this is something that maybe might be interesting investigating in the paper. I don't know the word limits, but if I have enough space, otherwise next articles. But it will be interesting to think about how, a reform that will make sense and that will be effective. Because I agree with you that the way in which peace operations exist right now, well, they're not very effective in terms of peace. It's true that a lot also depends on the specific mandate, what they can do or not. And it was very interesting to listen also to the relationship with the ICC. But again, this shows tension between promoting peace and promoting justice, and what peace operations are there for. So, yeah, thank you for your question. I'm sorry that it's just, really more rambling than anything, but because I'm still thinking about it. Thank you.
Thank you, Carlo. So for the two questions, the one is specific, Articles 36.3 and Article 33 of the UN Charter, and what is their relationship. Now, for those who don't have the text in front of you, Article 33 lists, without mentioning the Security Council, the options for the parties to settle their dispute and gives them a wide range of modalities to which they are referred without prejudging their choice between negotiations or doing nothing or conciliation or going to a court. And Article 36.3 is the one I mentioned, which envisages that the Security Council could recommend a particular form of dispute resolution. What's the relationship? I mean, I think I would say my formal response would be that Article 36.3 takes, is looking at the role of the Security Council as an actor in the dispute settlement process, and it starts by saying that at any point the Security Council can draw the parties' attention or nudge the parties towards one or the other of the means, and then in that sense it says, it gives this principled statement that legal disputes should go to the ICJ. So in that sense it covers a particular actor and gives preference or seems to give preference to a particular form or modality of dispute resolution mentioned in Article 33. But it is so softly formulated that I only think it's relevant. I mean, it's relevant not really operationally, but only for the statement of principle that is hidden in there. Because operationally it doesn't really do much. It's only about recommendations. The Security Council doesn't really recommend that often anyway. Then it has the choice of Article 33, pretty much whichever you want. Then it's to be guided by, according to paragraph 2, by the practice of the parties, and paragraph 3 by this principle in favor of binding dispute resolution. But all this is, I would say, is lacking teeth because, first of all, it's only a recommendation, and secondly, from the beginning, it's been made clear, even since the Corfu Channel case by the ICJ, that this doesn't create jurisdiction, but only exists within the framework of consensual jurisdiction established by the court, and the court itself has affirmed this twice. So I think it's a pretty, operationally it's not very useful, and the relationship is not very practically relevant. In brackets, I think that's an interesting question for doctoral researchers or master thesis writers, whether the Security Council could override the whole consensual scheme if it acted under Chapter 7. That's been a live debate 20 years ago. At the moment, one cannot really envisage the Security Council doing that, but I think that would be an interesting question to which I would be curious to hear a deeply in-depth researched response. You also mentioned about hubris and asked what had I meant. Maybe I was using flippant language. I think I said even at the time when the UN was in its ambitious, optimistic, and perhaps in retrospect, hubristic mode, it didn't seem to go back to the security to the court as the preferred choice. And maybe I need to qualify that a bit. So I think at the beginning of the hubristic or optimistic phase of the UN, at least the one that I recall, there's the Agenda for Peace, which did emphasize the notion and the value and desirability of more binding dispute resolution. I think my flippant use of terms was probably more to suggest that even in the golden 90s, if you want, when I went to law school and sort of, I don't know, was brought up into international law with this, I mean, the sky seemed to be the limit. Even then, the court was not very active, and it seemed to be other tools that were tried out. Security Council in particular, and all of a sudden everything seemed possible under Chapter 7, and there seemed to be no limits to what the Security Council should do. It all strikes me in retrospect as a bit mad. But the court even then didn't feature so prominently, and that's what I meant. And when I said hubris, I think that in retrospect, how can we possibly look at the 90s as the golden age when 1 million people died in Iraq, when the sanctions were used, and when sort of all these projects driven by international law now create all this trouble for us, not in the remit of my topic, but you could say that, I don't know, in investment law, everything that was created in the 90s now is looked at with a lot more suspicion. So maybe it was all a bit hubristic, the way international law was taught when I was a student. But I leave that for better qualified people to judge. I was using flippant language, and that's perhaps my excuse for the term hubris.
As for Christina's question, thank you, about positive complementarity. Well, I think this is exactly an issue where we shouldn't try to enforce a balance between peace and justice by forcing the statute or allowing the court to do a balance that it's not for the court to do, it's for someone else to do. Because the rule on complementarity is quite clear to me. The court can step in when a state is unwilling or unable to prosecute. And it's true that the Office of the Prosecutor has started this endeavors to get the states do their share in prosecuting, but it's doing their share for prosecuting. All transitional justice mechanisms that do not involve prosecuting major crimes should not be an excuse for not allowing the court to step in. So positive complementarity is fine as long as it ensures prosecution of major crimes. Otherwise, it's not what it's meant for, I think.
Thank you very much. And now we come to our third round of questions. I'm sorry, Marina Mancini, yes, please. And then...
Yes, thanks. I have a question for Chiara Radaelli. I found very interesting her notion of positive peace, and she mentioned actions that may bring peace, but that constitute breaches, violations of international law. And she mentioned the case of recognition of sovereignty of Russia over Crimea. And well, I focused on this example, and in my view, in fact, this could be a case of an action that only apparently brings peace, but that in fact actually may carry out sows the seeds of a new war, since on the basis of this experience, Russia may decide to plan and carry out acts of aggression against other neighboring states, and other states may decide to follow the example of Russia. So have you considered the case of actions that only apparently brings peace, but in fact sow the seeds of new wars? This is my question. Thanks.
I think we had, there was one question there, then I'm sorry I don't see in the background, then there's Luigi Crema, and then there's somebody else whom I can't identify.
Marco Pertile.
Okay, sorry Marco, I just didn't
problems.
see you.
No problems. So that's for Chiara. Chiara, thank you very much for your talk. I wanted to question the dichotomy. I wanted to put to test the dichotomy negative peace and positive peace, and see whether it holds, whether it makes sense. I'm not entirely sure. I think I'm joining here perhaps what Marina Mancini just said. I think this subdivision, peace and conflict, is very simplistic. We have different shades of conflicts. And I wanted to ask you what you think about, for instance, precisely ceasefires and frozen conflicts. That's the absence of conflict. Do we equate the absence of conflict to the absence of hostilities? Is there a difference between hostilities and conflict? Or do we take the view the conflict ends when there is a peace treaty? So this is the first question as to negative peace, I would say. Peace treaty versus a ceasefire. Is ceasefire for 20 years okay? Is that peace? That is the first point on negative peace. On positive peace, I would try and see whether we can define positive peace. What do we mean by justice? That is quite a hurdle, I would say. So the question goes, don't we need to look perhaps at procedural fairness so that positive peace can be defined as peace reached through a fair procedure? Peace reached through the involvement of all the concerned parties. So that perhaps we don't even call it positive peace, we call it objective peace, because the involved parties find an agreement. So perhaps that's a more realistic way to tackle the hurdle of defining positive peace, which puzzles me a little bit. So I wanted to ask, to see your opinion on this. Okay.
Thank you. I'll start from Christian. I'm not going to be theoretical. I just want to have a very open question. What do you think is going to happen in the drafting of treaties after this season of active states pursuing at the ICJ their problems in a different way? Because it's not the ICJ who's acting this way. The states are taking a bold move, and the ICJ sometimes would love to shrug and say, well, guys, can you think about it in a different way? But when Qatar and the Emirates come up with any possible way to deal with each other. So are you seeing a different way to draft treaties these years? Do you have, a palantir to tell us if there would be more trust or less by other states that are more keen in evaluating the danger and the weight and losses of the ICJ jurisdiction? The second point is more a framework question for Chiara. I agree with all the people who said that negative peace is an important pillar of international law. But having said so, I see that we can go in a direction of, let's say, opposing peace with an action against it only after a careful cost-benefit analysis. So it's a case-by-case situation. All the rest of your argument about positive peace should remain, in my opinion, under the large hat of right to development or all the work of the UN that the UN do in different venues. No, so in a certain way, on purpose, the idea of an integrated approach to human development and therefore to peace through growth and flourishment was removed from natural law into a policy-based approach with agencies and work of other UN parts on the ground with states. And then we selected to bring out only negative peace as lack of direct war because of two conflicts that destroyed Europe and other places. So again, but what about Rwanda and what about Bosnia and the roaring 90s that were mentioned? Yes, in those cases, a cost-benefit analysis would be useful, but that's a very special occasion, okay? And that's probably for the UN, Security Council, procedural fairness, and the risk of states just standing up and saying, I'm going to intervene even if it's prohibited because it's too much. No, and then you have to suffer the diplomatic consequences. But those are two branches that on purpose have been, kept aside from each other so that we don't use one of them to play against the other.
Thank you. Let's have I think is there any more questions? I would take them all at this point, and then we have a final round of answers, and then we close, huh? That's okay? Okay, then please. I think Chiara has questions, but also the others. Shall we start with Christian now? Just for...
Okay, thank you. Thank you. That's, what will it do to the... You ask about sort of what are these curious, strange new cases doing to trust in the court, and your focus was on treaty drafting in particular. Short answer is, of course, I don't know, but I'm relatively optimistic that it cannot get worse. So I think your question seems to assume that there may be an element of trust reflected in treaty drafting, referring cases to the ICJ, and that would be now breaking away in light of, as respondent states see what is done with these clauses. And I would share this in the abstract. So if we had had a tradition for the last 20 years of, let's say, constantly drafting strong ICJ compromissory clauses, I think that would now stop. But I think it stopped 50 years ago. So what is there to lose? I think the last clause that has ever been invoked before the ICJ from a multilateral compromissory, I have to double check this, but my sense is that it's the third convention from 1965 is the last one that has ever been invoked. And of course, there's been a few since then, but they all come with so many caveats. Sorry, the Racial Discrimination Convention. I think that's the most recent multilateral compromissory clause that has been invoked. I have to double check it. There were attempts, of course, in the Congo-Rwanda case about, let's say, CEDAW and all this, but the court put a brake on these. So it seems to me that the picture is already quite bleak, and therefore the missing trust is a feature of the last decades, and you can't really go down from zero, as it were. So I'm expecting there to be no more compromissory clauses, but on the other hand, there haven't been no more relevant ones recently. Now, I think I'm slightly, I wouldn't quite say agnostic, because in some ways compromissory clauses are quite protected. You can, of course, get out of the treaty, and some states may do this, denouncing treaties. The US has been denouncing the Consular Convention Optional Protocol. It's denounced the Treaty of Amity. So let's say 2 or 3 cases down the line, you opt out in the way that in investment law, it happens now all the time, but minus sunset clauses. So they're gone then immediately. So this is happening, but you need to get out of the treaty. So you can't, in retrospectively enter a reservation, because typically the reservation would have to have been formulated at the moment, at the early moment. So that's not a possibility. And getting out of treaties may be okay for the US, especially if it's a dodgy treaty like the Treaty of Amity that, where there's no amity left, you might as well denounce a treaty with Iran. The US seems to have typically waged wars with treaties, with states that it has treaties of amity with: Iran, Nicaragua, I mean, these treaties are zombie treaties anyway, so they might as well be denounced. And otherwise, it's tricky. I mean, you can do it if it's a protocol that you denounce, like for these Vienna conventions. But if the compromissory clause is a real part of the treaty, I mean, will Israel now denounce the genocide convention, having been caught out? Possibly, but I mean, look what the drama case it takes for Israel to move out, and we're not even sure that Israel will, which is not really feeling many constraints, it seems, at the moment. Even Israel may stay in the genocide convention because of the reputational factor. So I'm not assuming many, if you want, states to move out of the existing framework of compromissory clauses. And I think that's the charm, that they cannot retrospectively enter reservations, which is what they would probably now do, all of them, if they could. And I think in that sense, I see the compromissory clause regime to be slightly more ring-fenced than the optional clause system, where we have so much fluctuation, where we have maybe sort of a gradual increase, but the big players have all, some of the big players have dramatically moved out. France, the US, or dramatically increased the number of reservations, the UK, Japan, Canada. So who knows, Germany may soon enter a new reservation, having been burned once, as it were. I don't know, I speak as an observer. And with optional clauses, you can always shrink the scope of jurisdiction in a way that you cannot for compromissory clauses unless you leave the treaty. And so in that sense, and this is slightly beyond your question, I'm sort of resigned it cannot get worse, and I'm not really seeing states massively moving out of the treaties that have those compromissory clauses. But of course, you might say that's the residual optimism that will prove to be naive in 10 years if we meet again discussing the 90th anniversary and all those treaties would have been cancelled. But for the next 10 years, I'll keep that residual naive optimism. Thank you.
Thank you, Christian. Chiara?
Thank you for all your questions. You actually highlighted the problem with the tension between negative and positive peace, and starting with the first one, what you mentioned about, well, if we give Crimea to Russia in a way, so violating territorial integrity and international law, just for stopping the war in Ukraine, well, it is obviously not only will be unjust, but it could also bring new wars, paving the way for Russia to invade other countries and to expand in the Baltics and Poland potentially. And this is exactly why the idea of positive peace started to emerge. The idea that, well, if you have just absence of war, this doesn't necessarily mean that you are actually promoting the interest of peace. Absence of war in itself is not enough. You also need the conditions to prevent new wars and basically to ensure no repetition when these wars happen. So the idea of positive peace informs the period before a war, but also in the leading up after the war, so the transitional justice moment. This is also when positive peace could have an impact. But the thing is that then the problem is that what do we mean by positive peace? And how do we find a balance? So I don't have an answer. I'm still thinking about it. I'm not even sure if it's up to me to provide an answer. But I do think that it's important to discuss these issues, because if we keep saying that the UN and the international community have as ultimate aim the promotion of peace, we should be clear about what do we mean by peace. And, well, my article, it's really a humble contribution about, well, we have no idea. And peace might mean several things. At the end of the day, it's a political choice, but right now, this choice is implicit. There is no an actual discussion around what do we mean by peace and which kind of peace the international community wants to promote. And I think that there are pros and cons in promoting one or the other notion of peace. And this leads me to Marco's question about what about, do you need a peace treaty? Do you need is a ceasefire enough? Do you just need the end of hostilities when it comes to negative peace? And this is actually a very interesting question. I'm still playing a bit with the notion of negative peace. And I just hired a research assistant who is actually going to be in charge of going through all these instances, because I really want to do a systematic screening, not only of peace agreements, but also in general Security Council, General Assembly resolutions. And it's a huge work, which hopefully I will be able to include in this article. But the thing is that, and at least my first intuition probably is that in terms of negative peace, I don't think it's necessary to have a peace treaty to end a war. There are many wars that end without a peace treaty. However, a ceasefire might not be enough, and a ceasefire doesn't really mean that the war is over or that it will not be resumed in the near future. So there are actually conflicts where the intensity of violence is very high, but there is a ceasefire. Sometimes you have a peace agreement like in Colombia, and then you have members of the FARC who actually keep fighting, and so the conflict continues. So probably this should be done on a case-by-case basis, and I wouldn't be too formalistic about talking about peace treaties or ceasefires, and I would actually look at the situation on the ground. And when it comes to positive peace, what is the meaning? And, well, this is actually the big question, and I guess from state practice, it seems that the trend is more around the respect of human rights or preventing the commission of atrocity crimes. It will be interesting, as you said. I mean, I'm not sure if I understood correctly. Do you mean like multilateralism in the sense of?
My approach was introducing this idea of procedural fairness. Instead of looking at the equilibrium of fundamental values, which is also always difficult, let us look at the procedure and whether the procedure is fair. That could perhaps guarantee a form of justice, but a procedural justice, because substantive justice is impossible to define. That was the point. And whether you believe that procedural fairness can be valuable in defining what you call positive peace, and I would call perhaps objective peace, but that is my main point.
Apparently they didn't hear you because you weren't talking, but I heard you, and you simply repeated your question, so I think that those who are following at home, can still rely on your question and what you said before. It's actually an interesting point. I didn't think about it. I guess the main issue is still what procedure, and how do you monitor it? How do you enforce it? But it's an interesting idea. I need to think about it, so I will come back to you tomorrow. But yeah, I think it's, I really have to think about it, because I find it difficult to imagine how could it play out in practice, to be honest. But so I'm not completely sure, but I can see your point, and indeed, justice and equality, these are very abstract concepts, and anything could fit in such definitions. So that's why I think that it's very risky, and it's also what Professor Ronzetti was saying before, to promote positive peace without an actual definition based on concrete elements. And then about the last question, and I know that my answer stands between, me and your freedom, so I will be quick. So the thing about negative peace, and obviously, I mean, there are cases when violating, in a way, negative peace, so using force to promote human rights or using force to stop atrocities, I do see the point in that, and indeed, there might be cases when this is necessary. And again, the assessment, I do agree with you, should be done on a case-by-case basis. Now, the thing is that I kind of see it in a way as a lose-lose situation somehow. Because you mentioned, for instance, Rwanda, and then the intervention in the former Yugoslavia, and NATO in Kosovo. And like in Rwanda, nobody intervened, and the international community, Western countries were criticized, the Security Council was criticized. And then you have Kosovo, you have an intervention, and basically the countries that intervened were criticized because they did something that was actually unlawful. So what are you supposed to do? And well, as we all know, humanitarian intervention didn't really solve the issue, and R2P needs the authorization by the Security Council, so again, we don't have a solution. I'm not sure if there is a political will to find a solution, and I think that probably states, considering how difficult it might be to find an agreement on these issues, probably states kind of prefer to have a gray area, excluded from the crime of aggression, and where you kind of can play around. So, for instance, in the case of NATO and the intervention, there were some consequences, but nothing major. I don't think there were any sanctions, for instance. So it's an interesting point, and I do think that at the end of the day, it's really about looking at case-by-case analysis and to understand what are the values that the international community seeks to promote. I stop here.
Thank you very much. I think you deserve a last minute for a comment. Alessandra, then we close the session.
Yeah, I didn't have any questions, but I just wanted to jump in on this discussion on positive peace and negative peace. I do understand the value of the sociological concept of positive peace, but I also share the discomfort that some voiced on the legal notion of positive peace. It's the same feeling that I have when we discuss responsibility to protect. I see what's the point, but I really can't see how this can be a legal concept. And also why we need the legal concept of positive peace, because you said the ultimate aim and the ultimate purpose of the United Nations is peace. Well, the United Nations has several purposes, and I'm not sure they are on a value scale. First of all, it's peace and stability is not negative peace, it's definitely something more. And then promoting human rights is a purpose, and self-determination is a purpose. So maybe it's more a matter of striking a balance between these different purposes in the light of existing rules. This is also important. But then on the other hand, I was also thinking that the UN itself is pretty inconsistent on what peace is. Because if we think about threat to peace and things that have been qualified as threat to peace, smuggling is a threat, smuggling of migrants is a threat to peace, piracy is a threat to peace. This has nothing to do with negative peace, definitely. So I think you're right, we need to think more on this. Thank you.
I wholeheartedly agree, and thank you all for this very interesting discussion, the speakers, of course, but also the members of the public for engaging with them. Thank you so much, and we'll meet again tomorrow morning for the second session of the conference. We will start at 9:30 in this room. We now go on with the meeting of the editors and of the Italian Yearbook. So thank you so much for those who have attended the conference. Thank you.